Hi there, this is Chris Berry, Certified Elder Law Attorney with the Elder Care Firm. Today we're going to talk about the 4 ways that assets get out of your name when you pass away, otherwise known as estate administration. The first way is through joint ownership. Joint ownership is great between husband and wife. Husband passes away and a checking account goes to the survivor, the wife. However, we don't recommend joint ownership for anyone other than husband and wife because you're opening yourself up to a whole slew of other problems, including liabilities of the people named to that joint ownership piece of property. The second way to pass assets out of your name when you pass away is through beneficiary designations. So this is life insurance, 401ks, IRAs. When you pass away, it goes to whoever you've named as a beneficiary. The problem with this, it's like a pillowcase of money. You're just handing a pillowcase of money to that beneficiary. What happens if they were to go through a divorce, lawsuit, creditor action, bankruptcy? Then that money could be lost. The third way to pass assets out of your name when you pass away is through trusts. And we have different types of trusts. We have revocable trusts as well as castle trusts. Revocable trust is great at avoiding probate and controlling the distribution upon death. And then we have our castle trust, which avoids probate, controls the distribution, but now builds in asset protection, where we can protect against long-term care costs as well as lawsuits. But if an asset doesn't pass through joint ownership, beneficiary designation, trust, then it ends up going through probate. And that's what most people want to try to avoid, because in Michigan, that's a court process that takes at least 5 months, and it's costly. On average, about 3 to 5% of any assets going through probate get eaten up in costs. So we know that we want to try to avoid that. Now, what's the one thing I didn't mention? A will. A lot of people think a will avoids probate. However, it does not. All it does is gives instructions to probate court on how to administer your estate. So we have 4 ways to pass assets upon death: joint ownership, beneficiary designation, trust, probate. Now, most people do end up relying upon a trust, but it's not 100% necessary. If you do want to learn more about this and learn about the revocable trust versus the castle trust, or whether you should rely upon the beneficiary designations, please attend one of our upcoming LifeCare Planning Workshops. You can learn more at michiganestateplanning.com/workshop. Thank you.